in the Court of Law. He interestingly lectures particularly on patent law issues both in Germany and abroad, and he's been appointed as a visiting faculty in NLU Delhi. He also is teaching in many other organizations, and he's also member of Licensing Executive Society, FICPI, AIPPI, GRUR, and Association of Intellectual Property Experts. When he is not working on IP, he enjoys spending time with his family, hiking, skiing, playing soccer, traveling, listening to classical and other music. Welcome, Markus. We look forward to have your valuable inputs. Now we have Dr. Sadhana Srivastava. She is Senior Scientist and Registered Patent Agent, Head, Innovation and Translation Research Division with Indian Companies. It's divided into 4 sections. One is like what kind of IP protection is relevant in various jurisdictions, and we are lucky that today we have people from Russia, we have panelists from Germany, India, and US. So that gives us a very wide perspective of how the IP protection has been in various jurisdictions. And then second part will deal with IP protection versus public health, which has always been a very critical issue. Then has really compulsory license or patent waiver helped the companies or the world? And how do we, the fourth part is how do we maintain thin balance where is profiting of the companies is also taken care of along with public health or especially at the time of situations like national emergency when we had in case of pandemic. So to start with, the word vaccine has been derived from a word called vacca. It is a Latin word which means a cow. So English physician Edward Jenner in 1796 coined this particular word when he was inserting pus from cowpox lesions into open cuts on human patients to prevent smallpox, and that was the time it was realized that if you insert dead or weakened germs to a person, it enables production of antibodies because the dead cell or the germ acts as an antigen against which antibodies produced by the body. So you can insert these germs into a healthy person, which in turn results in generation of antibodies which prevent occurrence of a particular disease. So IP protection and vaccine is an important topic because vaccine, end of the day, is a life form. So protection of IP, whether possible, not possible, what kind of inventions in this domain they can be registered or not registered. If registered, then in case of pandemic, how we should meet the public demand. So there are lots of ethical, non-ethical, sensitive issues related to IP protection and vaccine. If we look back to history a bit, there was a time when lots of people were dying of HIV/AIDS in South Africa, and that was a time when lots of patents were there with the big companies, and without bothering about the patents, Indian company Cipla started supplying drugs to Africa. Okay, and the drug which was previously sold for $10,000 per annum was supplied by Cipla at 3% of the price. And then this became a very big issue in international forums, and during the 4th Ministerial Conference of TRIPS, it was decided that when you have to choose between public health and patent rights, there has to be a substantial consideration for public health. And that was the time when compulsory license came into picture, and in India we introduced Section 92A for export of pharmaceutical compounds to another country when there is an epidemic, pandemic, extreme urgency kind of situation. So today we will talk mainly about the COVID time when apart from many other therapeutic drugs, COVID vaccine was the one which was most talked about. So to start with, we will understand the patentability of COVID-19. I will not say COVID-19, the vaccine in general in various jurisdictions. So I would request Dr. Ramani, who is specialized in US laws, So just throw some light on patentability of vaccine in the territory of US, because US is the country I feel where Diamond versus Chakravarti case first time depicted that the life form can be patented if there is a human intervention. So over to Dr. Ravi.
Good morning, everyone.
Presenting among such distinguished presenters, and let me start by saying that, as you may know, in Russia you have options of obtaining a Russian patent or Eurasian patent which covers Russia. Just like in Europe, you can get a national patent of some country or can get a European patent covering that European country. For the purposes of saving time, I won't be speaking about the differences between Russia and Eurasia. There are much more similarities than differences in approaches. There's no Russian definition of vaccine. By vaccine we mean the same thing as everyone. It's a medical preparation that imparts long-term immunity to a human being, immunity against a particular antigen. Okay, my first slide. In both legislations, vaccine per se is not mentioned, and this is kind of understandable because there are no specific requirements imposed on a vaccine as far as patent legislation in Russia and Eurasia is concerned. I guess it's safe to say that the approaches to vaccines are the same as in general approaches to patenting compositions or immunogenic compositions. Here I list just few general requirements imposed on compositions. As far as claim drafting is concerned, we need to indicate the purpose and quantity and amount of ingredients. Russia and Eurasia have slightly different requirements regarding indication of the purpose. In Russia, it is not sufficient just to say it's pharmaceutical composition. You have to indicate a more detailed medical application or activity. In Eurasia, you can get away with this. You can just say it's immunogenic composition or it's pharmaceutical composition. As far as characterization of the makeup is concerned, it is sufficient if the activity of the composition is defined by the active principle. It is sufficient just to mention that the active principle is an effective amount, and that's it. We don't need to say anything else. When we speak about requirements, I won't say probably anything specific about the three patentability requirements. We all know them. It is industrial applicability, novelty, and inventive step. Well, probably one thing. In Russia, industrial applicability, when they check industrial applicability, they check whether the purpose of the invention is shown to be achieved in the examples. As for sufficiency of disclosure, this is pretty much about making sure that the scope of the claim is justified by the available experimental data. So it's not sufficient to list just hypothetical embodiments of the composition. It is necessary to show, at least in one example, that the purpose of the invention is achieved and the purpose of the invention is realized and the technical result is achieved. And the examiner just needs to make sure that the invention is implementable over the entire scope of the claim in the eyes of a person skilled in the art. Since we're talking about vaccines, I just wanna mention that apart from vaccine as subject matter, of course, when you protect inventions relating to fighting infections, there is a wealth of different kind of subject matter that also get involved. So here I list the generic concepts of three first patents issued in Russia as far as anti-COVID vaccines are concerned. The first two relate to our vaccine, Sputnik, which I'll show on the next slide. And the third one is a subunit vaccine, also patented and also produced in Russia. As you can see, there's no word vaccine in the first two patents, and it's not necessary. As I said, nobody expects that you present clinical data when you file a patent application. So we need to show just that your composition is immunogenic, that your antigen is produced in cells. And in case of Sputnik vaccine, the data included in the patent had to do with the production of the antigen in CHO cells, and in human had 2,093 cells, and mice were challenged with the antigen, and the titers of their antibodies were checked in some time. So yeah, you can see there's a genetic construct, a strain of CHO cells, a method for obtaining a recombinant RBD protein, and things like this. So all this is covered by patents. And the last slide of this section, just a couple of words about the vaccine which is covered by the first two examples on the previous slide. It's a Sputnik vaccine which was approved in 91 countries. It is an adenovirus vaccine based on replication-deficient adenoviruses of two serotypes with the S gene of SARS-CoV-2 inserted. It is the first, to our knowledge, this is the first patent ever granted on a COVID vaccine and the first registered vaccine. With this, I guess I'll stop for now and continue later.
Thank you so much.
Yeah, so thank you very much. Assuming that this was going to be a panel discussion, I've not prepared any slides, but I'm nevertheless very much grateful to my co-speakers who have already made some wonderful introduction to the topic. So when we talk about patentability of vaccine claims in Europe and in Germany, what I understand by the term vaccine claims or vaccine patent is also a composition comprising some form of virus, some form of microorganism, or some subcomponents thereof. And as in the US and as in Europe, we have the general patentability requirements. So in Europe, patents are granted for inventions in all fields of technology which are new, involve an inventive step, and are susceptible of industrial application. That is the basic provision of patentability in the European Patent Convention. But then in the subsection of that particular article, which is Article 52 of the European Patent Convention, it says that a mere discovery of something is not an invention. So if you are one to have discovered a virus or to have discovered a microbe and you have done nothing else to it, then you will not get a patent for a mere discovery. What we also then have in the European Patent Convention is Article 53, which is an article similar to what we've heard also from Dr. Romani, exceptions to patentability. And this Article 53 says basically that European patents shall not be granted in respect of plant or animal varieties or essentially biological processes for the production of plants or animals. But then again, also in that provision, there is then the exception to the exception, which stipulates that this does not apply to microbiological processes or products thereof. Now, if you consider a virus the product of a microbiological process, or a microbe as a product of a microbiological process, then a virus or a life form or bacterium may well be a patentable invention. Now, the European Patent Convention not only has articles, but it also has rules, and in that context, in the context of patentability of life forms, what is important is a particular rule, 29, which states that the human body and the simple discovery of one of its elements cannot be a patentable invention on the one hand, but if you then isolate that element from its natural surroundings, or you produce it otherwise by means of a technical process, and that explicitly then also includes the sequence of a protein, the sequence of a gene, that may constitute a patentable invention. In other words, as opposed to what we have in the US, where Dr. Ramani has already outlined that you have this myriad decision which changed the whole scenario. In Europe, it suffices that you can patent something that occurs in nature if you are the first to have isolated from its natural surroundings. So isolated viral sequences and components may constitute a patentable invention, and if they are part of a vaccine composition, they may certainly do so under the provisions of the European Patent Convention. So what in the sort of last part of this section, I would like to put the focus on is, however, an additional aspect, namely the question of whether by such vaccine composition, for which we've just heard that this is a patentable invention in Europe, a particular therapeutic effect is achieved. And that is what Dr. Ramani has already said, that you should, in your patent application, irrespective of the jurisdiction, you should somehow explain what is so special about your patented composition. And in Europe, this may play a big role under two different concepts, namely under inventive step, and the question of whether a patent claim is obvious or not, and then secondly, under the question of sufficiency of disclosure, namely the question whether or not the patent application discloses the invention in a manner sufficiently clear and complete for it to be carried out by a person skilled in the art. So with respect to the first point, i.e. the inventive step, the question is whether you invoke the technical effect of such vaccine composition claim to prove that the composition is not obvious over the prior art. And with respect to the second point, you ask basically the question whether the examiner believes you that your wonderful vaccine composition does have the desired effect in order to function as a vaccine. Now, one important source of legal information are the decisions from the Boards of Appeal from the European Patent Office. And the Boards of Appeal have made it repeatedly clear that for proving such a technical effect, it is not always necessary to provide clinical data. So as Dimitri also said, as I understand it from Russia, you do not have to present clinical data. But in Europe, it's as long as you somehow make it plausible, that's the term, or that has been used for a long time, that the technical effect has been achieved. So this is the concept of plausibility, and the question whether or not that effect has been made plausible in the application. Now, the Boards of Appeal of the European Patent Office there are different streams of case law. They have required different levels of plausibility, and I'm not going to go into technical details on that. And a second sort of important point is that there was a long discussion on whether an applicant can rely on post-published experimental data. Now, in 2023, an important decision by the large Board of Appeal has come out, which I believe has also made headlines here in India. At least over the last couple of days, I've been repeatedly approached by some of my Indian friends and colleagues. That was, the large Board of Appeal is the highest body of jurisdiction in the EPO. And in that decision, which is G2 out of 21, the large board tried to get somehow away from the concept of plausibility, because if you look in the European Patent Convention, you will never find the term plausibility anywhere. And what this decision effectively said, it discussed the question of whether a technical effect has been achieved in the context of inventive step. And the decision made 2 points. In order to prove the presence of a technical effect, you can rely on post-published data, meaning that if you in your application have shown that your vaccine composition somehow induces some immunogenicity, then you may later on, when you have clinical data, submit them to the patent office even though they were not part of the patent application as filed, and you may possibly rely thereon. And for the purpose of inventive step, you may rely on a technical effect if, and I'm now quoting from the decision because I sort of wanted to highlight to you how sometimes difficult it is then to deal with these decisions. If the skilled person using common general knowledge and based on the application as filed would derive such technical effect as being encompassed and embodied by the technical teaching of the application. Now, what do you make of that? In my view, this will open up a whole field of new discussion. It has certainly done that, and so it remains to be seen what the sort of the lower boards of appeal, the technical boards of appeal, will make of that. What it means to me is that the technical board of appeal has essentially changed the concept of plausibility and replaced it by the term credibility. So they have replaced the term and they have ruled that the amount of data that are required in a patent application to be inversely proportional to the level of credibility that a person skilled in the art would attribute to some claimed technical effect. And so as a take-home message, I would say that the more extraordinary your claims are, the more extraordinary evidence is required in your patent application. So in other words, if you in your patent claim somehow write that this is a vaccine composition for achieving sterile immunity, in the sense that this will be lifelong immunity, then you would have to prove that actually by your data. But if you just say a vaccine composition comprising protein subunit XYZ, then you may not require so much technical data in your application as filed. So make it credible in your application that the effect which you rely on in the context of inventive step and in the context of sufficiency of disclosure is somehow credible. And I'll leave it with that. Thank you.